Judgment in the appeal in the matter of J children.
In this case, too, the judgment will be delivered by Lady Hale.
It is a very serious matter for the state to take a child away from her family of birth. It is not enough that the state might be able to find someone who could bring the child up better than her parents could. The state can only intervene compulsorily if a child is at unacceptable risk of being harmed. Hence, Section 31, subsection 2 of the Children Act 1989 provides that the court must be satisfied, A, that the child is suffering or is likely to suffer significant harm, and B, that the harm is or will be attributable to a lack of reasonable parental care. The issue in this case is whether a court can be satisfied that a child is likely to suffer significant harm in the future if another child has been harmed in the past, and there is no more than a possibility that the parent who is now caring for this child was responsible for the harm to the other child. The case before the court concerns 3 children. 2 are the children of Mr. J and his former partner. They have always lived with Mr. J and have come to no harm. The 3rd was thought at first to be the child of Mr. J and his new partner, who is now Mrs. J, but turns out to be the child of Mrs. J and her former partner. That child, too, has come to no harm. But in 2011, when she was around 20 months old, the local authority began care proceedings in respect of all 3 children. They alleged that it was likely that all 3 would suffer significant harm in the future because in 2004, another child of Mrs. J and her former partner had died of non-accidental injuries. At that time, a judge had not decided which of them was responsible, but held that it was possible that either of them was the perpetrator. The local authority in this case relied solely on that finding as the basis for concluding that it was likely that Mrs. J would harm these 3 children. The trial judge dismissed the case on the ground that the likelihood of significant harm can only be proved by reference to past facts which have been established on the balance of probabilities. The Court of Appeal dismissed the local authority's appeal, but gave permission to appeal to the Supreme Court, because it was said in some quarters that the present law was causing, quote, consternation. The Supreme Court unanimously dismisses the local authority's appeal. It was established by the House of Lords in 1996 that a prediction of future harm can only be founded on proven facts. In that case, it was not enough to predict that a parent would sexually abuse a child in the future on the basis that there was a possibility, but no more, that he had abused another child in the past. That principle was reaffirmed by the House of Lords in 2008 in a case with very similar facts. It was also referred to with approval in 2 other House of Lords cases on other aspects of Section 31, subsection 2. Most recently, in 2010, the Supreme Court applied the same principle to the facts of this case. It held that the court could not hold that it was likely that the mother would harm a child in the future just because there was a possibility, but no more than that she had harmed another child in the past. In this case, the court unanimously reaffirms that principle. A real possibility that something happened in the past is not enough to predict that it will happen in the future. Only a finding that it has actually happened is sufficient. The court points out that cases which raise the issue in such a stark form are very rare. Usually there are many established facts from which it may be possible to predict a risk of harm in the future, although such facts must always be set in the context of the present situation of the family. In this case, there were other facts upon which the local authority might have relied, but it chose not to do so. In those circumstances, it would be unfair to the whole family to allow the proceedings to continue.